what is a good news for landlords, but it's a bad news for rentals. But my suggestion to landlords would be very clear. जल्दी से tenants वापस नहीं मिलेंगे. अच्छे tenants तो मुश्किल से ही मिलेंगे. अगर ये tenants आपको हर month पैसा देते आ रहे थे, then stand with these tenants today. They are not having any revenue. So, for an example, Delhi के अंदर जितने भी banquet halls हैं, उनकी एक treaty हुई with all the landlords. And उस treaty के % मॉडल ने पैसा कम करके रेंट देने की बात रखी, because there is no work at all. हाँ, अगर रेवेन्यू बेस्ड टेनेंसी थी, रेंट पे ये था कि भाई मैं इतना कमाऊंगा, इतना रेवेन्यू होगा तो मैं इतना प्रतिशत आपको दूंगा एज अ रेंट, उसमें फोर्स मेजर जरूर लगेगा, बिकॉज देयर वाज नो रेवेन्यू क्रिएटेड एट दैट टाइम. Now I come to a point where there is no written contract, there is no contract as such. Then in that case, the tenant has the slightest right to showcase to the court that, see, for this period, the possession, not with me also, the possession was with the government. Now this has not been argued till yet in any court of law. However, there is a slight scope left over which could be argued tomorrow. So I summarize this aspect. If there is a lease deed, which is a registered lease deed, which is a written lease deed, or even if it is not registered also, then instead of Indian Contract Act, Transfer of Property Act 108 would be applicable. As per that, आप lease deed को void create कर सकते हो. ये कैसे? You can give up your tenancy if you are a tenant, but you cannot do that I will not pay the rent for that period, but I'll continue with the tenancy of the future aspect. No, that is not permissible. My advice is get into the touch with your landlord, rent tenant, have a word with him, create either a revenue based model for future, or take a discount, or take it a point that today I'm not paying, tomorrow in case I earn, I'll be able to pay, I'll pay in future. This aspect would be a non-litigating aspect. It would be a win-win situation for both landlord and tenancy. For example, I say there are certain landlords which struck to this point that, you know, I'm going to take the rent for sure. And certain tenants just left the premises saying the lease has become void. We are leaving the premises itself. We are not going to pay any rent. Today, that property is still lying vacant. And for me, I believe those were commercial properties. It would be very difficult for that gentleman, the landlord, to get another tenant, at least on that rent for sure. So my advice for the purpose, so I summarize with his employer and employee, that have a word with your employee, create a revenue-based model as a salary for that employee also. If you get revenue, you get your salary. Make some fixed component in that salary so that they can prevail even without a revenue also. For that, foremost, create a budget, which is a necessity for any businessman or any business. And I now say, create a budget for this financial year. Now the businessmen are back on track. They have to create for this financial year. We don't know when this revenue is going to be back the way it was prior to COVID-19. For workman category, have word with them, get your resignations in case you want to terminate. If you want to lower down the wages, have word with them, give a 21 days notice under Section 9A, have a settlement with them. For the purpose of COVID, I didn't touch that topic. For the purpose of lockdown period, the Supreme Court has said for the workman category, sit along with the employer and decide what kind of a settlement you can arrive with the management. This is the recent Supreme Court orders on that aspect. So yes, I conclude vis-a-vis employer and employee. The documents would be holding many aspects in that. And I think that's how it would be from my side. Documents would take care of the further aspect. Uh, I can take up the questions, Himanshu,
So
whatever is there.
definitely, Anurag, we have a few questions already.
Yeah.
We have a question. He's asking, can permanent employees be terminated without full salary after giving 50% salary for May?
For May, can I have a look on the questions?
Sure. From Gotham, UK. I'll just repeat it. I'll just type it in for you again.
Yeah, okay, I got it. At 12.5, he put a question. Can permanent employees be terminated without full salary after giving 50% salary for May? So one thing is there, we are talking about the legality of termination. Can, yes, they can always. But who's going to check the legality is the courts. What we can say by experience is, no, a permanent employees cannot be terminated only by giving 50% salary of May. The point of contention is the contract between the permanent employee and the employer. So my point would be that if there is a contract, it talks about a stipulation, have word with that employee. If you're paying 50% salary for May, where there was a complete lockdown, in case the business was under lockdown and no revenue generated, you can have words with that employee. And I don't know about the April salary, whether Gautam, that April salary has been paid or not, because for April also there was no revenue generated by the business. So we have to see from the angle that it is not an employer and employee, it is basically a business which has to be considered vis-a-vis employment is concerned. So legality, as per me, that will be taken care by whether it's a workman or a non-workman. If it's a non-workman, then the appointment letter will prevail. But termination would be legal in case of a non-workman. It will not be held to be illegal. Only thing is a contractual damages, which is a part of the appointment letter, which that employee can seek in a civil court, not under a labor court or labor office, a civil court. And I don't know when these courts are going to open, and when it's open, what kind of a date is going to be given. So my humble advice to all the employees is that get in touch with the employer, create a model either to sustain being an employee, an employment where you can create some money out of revenue, or in case the employer is not able to hold on as an employee, create a retainership model. In case still not available, talk to him about whatever maximum amount you can have for your future respect, and start looking for a new employment or any avocation you can get. Because courts and this damages, only damages, not the reinstatement. It is reinstatement for only for the workman category. Only damages, that is, a appointment letter, contractual damages will be available through courts, that will through from a civil court. And I don't know how many litigation would be there on the head of the judges after COVID-19 and what kind of a dates would be given. Yeah, I believe I'm able to answer, Gautam.
The next question is from Sandeep Singh Anurag. He wants to understand how we can improvise the CTC.
Yeah, I'm able to read. Please specify more elaborately worker CTC under COVID if to be improvised for upcoming months as per statutory provisions. A great question, Sandeep. CTC, I always say, is a cost to company. It is not your salary. It is not a salary for any employee, any worker. It is cost to company. Cost to company would be having PF, ESIC, gratuity, earned leave, whatever cost a company has to incur upon an employee is CTC's cost to company. I will have an elaborate webinar on CTC for HR manager for sure to clarify that aspect. But vis-a-vis this specific question, for the purpose of workmen, minimum wages is a necessity. You cannot touch minimum wages in any way. So minimum wages and bonus, ESI and PF, these four things are a necessity to be a part of the CTC. If you are paying something more than the minimum wages and advance bonus, yes, that could be improvised, that could be made variable, but for that, you have to give a 21 days prior notice as per section 9A of the Industrial Dispute Act. If you are in tandem with your workers, if they are in agreement with you, then in that case, have a settlement created with them that this is going to be a revenue based CTC model. So minimum wages and variable pay. Variable pay would be a revenue generated in case you are able to get through those employees. Otherwise, 21 days notice is a necessity. In 21 days notice, they have a right, those employees have a right to go to the labor office to challenge that 21 days. Yeah, I think I'm able to answer, Sandeep. I'll receive another thing. Again, Gautam is saying, what will happen in NGO case? How to retrench all employees with legal aspects. Whether it's an NGO or anything, it is an industry under industrial dispute. Yeah. Anybody's there? I think. Yeah. So whether it's an NGO, whether you're making money or not, does not matter. You come within the purview of Industrial Dispute Act. For that, I always say even a milkman who's having a single buffalo and 2 employees will be industry and Industrial Dispute Act. How to retrench? For retrenchment, it has to be last come, first go. That is, juniors has to go first. For that, you have to create a seniority list. For 1 week, that seniority list should be on your notice board. Then, depending on your number of employees, there is a section 25F, which takes care of the retrenchment compensation, 15 days salary for each completed year of service. You have to pay that along with 1 month notice or notice pay. You can retrench those employees in that fashion. That is coverable under Industrial Dispute Act. But those employees will have a right that whenever you employ for that category, you have to employ them first. This is, and I think if you can have a link of my previous seminar, that seminar was talking about this aspect also. Himanshu, yeah, then this, yes. Kailash Kumar, how much salary we need to pay the worker if we terminate? So Worker Industrial Dispute Act is there. If he has completed 1 year of service with you, if he's a permanent employee, then your only aspect is retrenchment. And in case if you're a factory, so I'm getting in a bit of a detail of that also. If it's a factory, supposing that factory is in Delhi and it's employing more than 100 employees, 100 workers, in that case, you require a permission to close even. We are international group and closing our NGO, which we are running for society. PF is ESI. So international groups, international employee, if you have an international employee, Gautam, then that PF has to be paid on the complete salary. ESI will be as on 21,000, but for international employees, I mean those who are international person who came from out of India, who is not a citizen of India and works for you, you have to pay PF on the complete. They can withdraw in case there is a social security agreement with their country. In case it is not there, then you have to wait till they're 58 years of age to withdraw that. Ankur Mishra has put a question, can we reduce salary for live permanent employees in current scenario? Yes, you can reduce the salary for employees who are non-workmen. You create one agreement with that. It's a civil contract. It's a pure civil contract. If they doesn't want to continue with the employment, they have a right to resign and leave. But you can revise that CTC, the cost to company. Now, question is basic salary. Ankur, basic salary is having certain aspects called gratuity on that. So you cannot lower the gratuity part in case you say we are securing your gratuity vis-a-vis that basic part is concerned, and still lowering the basic, you may do so. But the second aspect comes up, the income tax angle. So I don't know what CTC bracket you're talking about, because the time we lower down the basic salary, the HR components get lowered down. So that is the two aspects you have to look into.